Hi, guys, welcome to another episode of Advantage Learning Bites at Coffee Conversation, powered by the Emerging India Forum, TIFF, Lions Club of Mumbai Shining, India Business Group IBG, and Indian Chamber of International Business ICIB. I am Jolly Singh, host at Coffee Conversation and associate with Prime Infotech Solutions. And today we have with us Aarti, a qualified solicitor and advocate with rich experience of over 17 years. Having graduated from Government Law College, Mumbai, she has worked with reputed law firms in Mumbai like Desai and Divans, Little and Company, and Fox Mandal Partners, working on range of assignments like litigation, property documents, family matters, finance documents, and corporate and HR matters. Aarti has handled various litigations in Bombay High Court, debt recovery tribunals, and other subordinate courts in addition to advising on real estate transactions. Currently, she is partner at corporate corporate legal advisory at YNZ Legal. She advises various corporates and international clients on technology and commercial contracts and aid them drafting, review, and negotiation of contracts. A very warm welcome to you, ma'am.
Thank you so much, Jolly. Thank you. It's a pleasure to be here.
Same here, ma'am. So today we will be discussing on the topic do's and don'ts while drafting commercial contracts. So let's get started, ma'am, for a very enlightening session. So my very first question to you, ma'am, would be that as the partner at corporate legal advisory at YNZ Legal, what are your primary responsibilities in managing and overseeing contractual agreements?
See, the primary role always for a contractual lawyer, whether an associate, junior associate, partner, anybody, is always to get the intention of the parties right in a contract. Now, deciphering the intention of the parties is the cue here. Sometimes parties feel that, it's a standard thing and it's all legal. So, let's leave it to the lawyers. But that's not right. The parties need to get involved. In fact, to give you a very clear example, the Sale of Goods Act is there in India. You might be aware of it. It's a very old legislation, but it has gone through very few amendments in spite of passage of more than 100 years. And that act itself, there are more than 15 sections which specifically make the provision conditional on the intention of the parties. Like the section will say, subject to the contract to the contrary, or unless a different intention appears from the contract. So the main idea whenever we talk about a contract is always to get the intention of the parties right, understand what the party is saying, ask them questions, get clarity, and then write it down, get it confirmed. So that is a very big responsibility, I feel, that contractual lawyers or anybody who's working on review, drafting, negotiation has in today's world. I mean, we are all aware of the burden on judiciary and commercial litigation. If the contract is drafted correctly, it takes much lesser time for judicial determination. So I always feel that it's very, very important for us as lawyers to get into the shoes of the party, understand what they are saying, and then write it down clearly in the contract.
Ma'am, in your current role at YNZ Legal, what specific challenges or opportunities do you encounter in providing legal advice related to the legal transactions?
Well, first, let's talk about challenges. The challenge always in a contract, the way I look at it is always kind of, it's like an arrangement which should stay between the parties. So, it cannot be broken. So it's very important for us. The main challenge which arrives at is, when you look at a closed mindset, like, one party, they just are closed. They have one template or they have one mindset and they will never give it up. So when you're agreeing with somebody else, there needs to be some give and take. So closed mindset, or somebody, sometimes when a relevant stakeholder does not come for discussions, the discussions get prolonged. Like, the party is unable to take a call. They just don't know, because when you talk or when you go for a discussion with the other party, there has to be some give and take. There has to be some openness amongst the parties so that, they can arrive at a resolution. Otherwise, it's difficult to get things concluded. the best opportunity I always see whenever I look at any assignment is when the client is interested as in intellectually, academically, and very much inclined and involved in the document. So if the client is involved, then the document comes out to be much better than what, a lawyer with, how many ever years of experience. It is very difficult. See, I'll give you an example. The other day I was reading through a judgment, and the point of dispute which had, which went on into litigation for almost 10 years was, one party was supposed to provide coal and some material to the other. The other party understood that they have to give them processed material, not the raw material. Like, if there are certain materials in various industries which need to be processed for it to be usable by the other party. Now, that processing is a cost. So, if I have assumed that I have to give you raw material, I will quote you X. But if I have to give you, say, processed, I will quote you X plus Y. So they said that, oh no, it was very clear. I was never supposed to give him, a process thing. The customer says, no, it was very clear. What am I going to do? He knows my business very well. So these kind of challenges can be avoided, when every time somebody gets involved, somebody knows that, yes, this is this is what the other party might be thinking in terms of scope. So that's the best opportunity, and that's when the best document, or that's when a proper agreement which actually shows their consent comes across. So that's the best opportunity, really, when you find, and you can actually do something there.
Ma'am, given the extensive background in corporate legal advisory, how do you approach negotiating and drafting commercial contracts, especially involving technology services and products?
So approach is always win-win. See, it's a contract, it's not a dispute. The parties are there to agree. The parties are there to close the transaction. So the approach always has to be fair, balanced, and a win-win approach. So it's not like, we always sit with this word that, yes, it has to be like this or it has to be like that. Some give and take, we can talk to each other, we can discuss, and discussion is the best way to resolve. That's the approach that I always have. And when it comes to especially a technology contract or any commercial transaction, pace and speed and a response time from the legal fraternity or from the lawyer who's looking at it is very important. Because the whole idea, I mean, why are we moving to fast-paced gadgets these days? We want pace, right? We want to do it quickly. The whole idea of maybe, today we have even fans which are remote controlled. So we don't want to spend time and effort in doing something which is, mundane, or, which takes time unnecessarily. So the pace is very important. So when it comes to, my approach always is to see to it that if a party is really in need of something, let's get on to it. Let's get on a call. Let's discuss it. Try to close it. Try to clean the draft immediately, and try to go for execution also. So unless and until you have that pace in a technology, in a transaction, it's not going to get through. And technology contract, when we talk about it, it's typically a little different from, the old style or the traditional contracts which are there. The technology keeps changing. People keep using new stuff. People keep, we just stumble on something. Now, of late, deep fake is the new thing. Everybody, we just don't know what we are seeing. Is it true? Is it not true? I mean, the PM of the country has not been saved by, the deep fake video which came across recently of him playing Garba. So it's different, it's the world is changing at a pace which we cannot even fathom. So technology contract, whenever somebody looks at it, it's very important not just to look at all the typical legal clauses, say, your indemnity is there, your limitation is there, your disclaimers are there. But apart from that, the schedules, or what is the SLA? Is it the actual SLA which the parties have agreed? Is it the are the service credits captured properly? Are the response time, security incidents, all these typical things which go somewhere in maybe an SOW or an SLA? It's important to just have a confirmation on each of it and make sure that the last version is the agreed version. Because in contract negotiation, sometimes we have like multiple versions. You'll see version 10, version 20, version 25, or so it's important to have that version control as a lawyer very, very strictly, so that parties do not end up signing that they had agreed to change, or they had told you during a call. So that the due care and attention which one says, that is very important when it comes to a contract. especially in a contract. I mean, any contract be it, but technology especially. So when we talk about those exclusions and, because the whole idea is it has to be fast, it has to be paced.
So, ma'am, talking further about the technology contracts, I feel the definition part and what all you are going to include in the contracts plays
Yes.
a very important role to define
Very,
whether a
yes,
dispute would be coming in future or not. So,
yes.
how do you see or view it while drafting the contract? What are the do's and don'ts that should be proceeded with while drafting those crucial clauses? In all the other various kinds of contracts, but given specifically for the technology contracts as we
Yeah.
are talking about.
It's a very interesting question, Jolly. So, see, what happens is when you talk about any contract, as you rightly said, and especially a technology or a commercial contract, see the from the first word of the contract to the last word of the contract, everything has to be seen thoroughly, vetted thoroughly, reviewed thoroughly. So, typical do's would always be, I mean, it will sound like some we are repeating, but understanding what we are agreeing, what is written there, accepting it in totality is very important, because I mean, when we talk about a do's, it has to be clear. Like, there are some points where I would say that, sometimes parties should also try to include some illustrations or some examples when we talk about a commercial part which is there in the contract. Like, sometimes the commercial understanding is pretty complex. It's not very easy for somebody, like if there is a lock-in period, like if you say sometimes there's a power purchase agreement which is there between the parties, and there is a phase lock-in. Like if you terminate in the fifth year, it is this much is the exit fees. If you terminate in the sixth year, this percentage will be calculated, this will be added, and this will be the exit fees. So when you have calculations of this nature, just include an example, because by the time the contract has to be, if there is a dispute, if at all, in an unfortunate case, the dispute is not going to arise in this, maybe say, 5 months or 6 months or 8 months. The dispute may arise after 7 years. And at that point in time, the stakeholders would have changed. I mean, the persons from both the organizations may be different and they may have a different interpretation of it. So to bring clarity into the contract is very important. You can think of various examples, and contract is not, there are no defined templates, or there are no defined, of course, we all work in a standardized formats. We all know that, yes, first you have to include definitions, then you can include interpretations, then you can include scope if you want. You can include, reps and warranties, you can include disclaimer. So there is an order that we all follow, of course, but bringing clarity and making an effort to bring that clarity into a contract is always very important from a lawyer's point of view. So it is okay to be innovative. It is okay to explain things in a presentable manner. There's no need to really write a 1.5 pager thing to explain something which is complex. If you feel it is coming out better in a table, you include a table. If you feel it is coming out better through an example, you bring out that example and you write that example there. Because there is no hard and fast rule that you cannot write this or you cannot write that, or you cannot include a pie chart if you want to do it. So feel free to do what you want, but make sure that the contract is clear. It should be clear to a third person. When that third person reads it, it could be the judge, it could be the arbitral tribunal, it could be your own management after 7 years. So it could be anybody. So main things to always follow in a contract is that it should be crystal clear. Now, another example that I'll give you here is, I came across a judgment of Calcutta High Court. It's a reported judgment. Now, in that judgment, the dispute resolution clause, Jolly, if you're aware, we always say that, in case of a dispute, if parties want to go for arbitration, they'll say the dispute shall be resolved through arbitration. Now, here the clause said, in case of a dispute, parties will make every effort to resolve it through dispute resolution, to resolve it through arbitration. Now, what do you mean when you say, I will make every effort to resolve it through arbitration? When I say every effort, am I supposed to go and arbitrate? Or am I supposed to make an effort somewhere? Now, effort, there is nothing like that, right? So the court ultimately referred the parties to arbitration, and court said that, yeah, if it says every effort, but the court had to spend valuable time. Counsels had to be appointed, parties had to sit and draft pleadings, because one party said, no, effort means I have not mandatorily agreed. I don't want to go for arbitration now. I want to go to the court. But then there is section 8, it says that no, when there's an arbitration agreement, you have to send the
Yeah.
parties to arbitration. So the court had to spend valuable time. Similarly, when we talk about things like I will do it, or I will make best efforts to do it, or I will make reasonable efforts to do it. So, things change, obligations change the way things are drafted in an agreement. So, never, I think when we look at don'ts, it would always be that, uh, don't take things lightly when it comes to a contractual matter, how much ever be the monetary stake on it, because it's not dependent. You might be generating a revenue of maybe a few lakhs, but in case of any problem, the liability could be of a few crores also. So this has been seen a lot of times, when in case of security incidents, or in case of, data thefts, or now, the DPDP Act has also come forth. So, randomly executing contracts, and because the stake is low and I don't have that much of time to look at it, I'm not sure if that's the best idea. Somebody should look at it. Anybody whom you feel, or if you're not sure about few clauses, get things vetted, get things done through somebody, or yourself if you're a lawyer. But somebody needs to look at it rather than, signing things just because I can't do anything about it. At least you will know what risk is there. Because, a lot of times people feel that, Array, it's such a, the client is too big. I will not be able to negotiate with them. Don't negotiate, but at least know your risk, what you're getting into, what you have signed up for. So that I feel is very important. And I always feel that executing formalities are also very crucial when it comes to a contract. So, while there have been cases, where parties have not signed the document, but they started operations on it, and the final drafts were exchanged on emails. So I send one final draft from my side to you, Jolly, assuming you're the other side lawyer. You see that, acha, theek hai, there were two things which were not right in it. So you correct it and you again send me the final draft. And then it remains in my, it remains as a soft copy. Nobody signs it. Now, the parties begin their engagement. After 6 months, there is a dispute. Now, my final draft said that arbitration is going to be at Mumbai. You corrected that final draft, gave it to me, said arbitration is at New Delhi. I never signed, you never signed. I never acknowledged also your final draft. So now where will the parties go? And what will they do in that case? So closure is very important when it comes to an agreement. And these days, yes, there is hurry. We all know the hurry when it comes, typically in this realm, March is very critical. Oh no, it is March, we have to close, we have to close, we have to do everything. So you start business, you sign something. Acha, we'll do an addendum next month. But when you sign, is it actually always going to happen that there'll be an addendum? Or there's a possibility that it might not happen. So I think the due care and attention is very important when it comes to a contract.
Absolutely, ma'am. Also, like focusing on the it's from your better point of view, I would like to understand that do you believe in the concept of being totally dedicated to your client and on the advice of the client, being biased while drafting the contract and manipulating the clause in such a way that if the other party is not able to recognize what kinds of liabilities and scapes are being put under the clauses, but at the same time you are being loyal to your client, and because commercial transactions happens in such a way that the client who is getting the contract drafted tries to get that one small benefit or the legal benefit if anywhere it is possible. So do you believe in that uh, that statement, or it is like better to go with the dividing the equal rights to both the parties and
No, no.
being
See, it's a very, very interesting question, Jolly. When you say that, where is that ethical line? See, that's the
yeah
line which every lawyer, every advocate has to draw for themselves when they are in professional duties. So to
yeah
manipulate a contract is something which I think, thankfully, I have never done, and I don't think I will ever do also. Because manipulating a contract would mean, writing something. I will tell them, Acha, I'm writing, a limited liability of 3 months, and I will write it for 1 month and get away with it. But I don't think there is any point also in doing that, Jolly. Because see, what happens is when you're in this profession, or when you get into an advisory mode, yes, I advise one party, I will obviously protect their interest because the other side also has a lawyer. It's not like the other side, if the other side doesn't have a lawyer, they have chosen not to have a lawyer. There is no dearth of good lawyers in this country. So it's not like, the other side is, is a Pardhanasheen woman or some, that there are certain categories of
Yeah,
people whom you have to support and you are in a fiduciary duty. Or, the other side is a minor or the other side is somebody else. So it's not that, there is a level playing field when it comes to contract and commercial laws. But manipulating or doing something and going beyond your professional duties is, I think, an absolute no-no. And that's what anybody will tell you. It's just not worth it. Because, clients come and clients go. We all know that. So to do something extra is different to put something in a particular way or to present it in a manner. Like if you look at litigation also, so in litigation we always protect our clients' interests. We are not, we are supposed to do that. That's our duty to them. But again, we are agents of the court also. We are not going to cross the ethical line and do something else, because ultimately it's a practice that has to go on till the last day of your life.
Absolutely. So, like, ma'am, summarizing whatever the points that we discussed, and also like adding points further into our conversation, what do you
Yeah.
think are the specific do's and don'ts that a legal professional should, like, for the bare minimum, start with while drafting the contract for their clients, commercial contract especially?
Yeah, when somebody starts drafting, the first thing always is to understand yourself. What is it that you're drafting? See, don't get into the mode when the client, always understand what first thing is, always ask questions. What am I supposed to do? What are you doing in this relationship with them? Is there any proposal which is exchanged between you all? Once you see the proposal, then you sit with the client again and ask him, do a background call or do a background meeting. First understand, actually, what are we getting into? What is the relationship? Are the commercials finalized? Have you decided with them what is the term? Is there a commitment that I will, you will purchase? Is it a license, or are you outright purchasing the software? Or, are you getting an assignment of the IPR in yourself to your entity? So ask them all the relevant questions. You can also prepare a checklist. Like,
Yes.
we work a lot on checklists also. Like we do a lot of, when it comes to website terms and conditions and privacy policies, or, click wrap documents, like I agree, I accept. So I agree, I accept means the other party is not going to be there with you to sign at that, or, to tell you their view generally. We all, we just say, I agree, I accept, and we move on in life. But at that point in time, always understand and sit with your client, understand from them what is it that you're doing, get their inputs, write down the draft, make sure that you have followed. There are multiple things available on the internet also, which are the basic clauses which you should always have in a document. So always have that. We at YNZ Legal, we also publish a lot of articles, through our Wednesday Wisdom series. It comes out every Wednesday on LinkedIn. So we also write a lot of stuff on this. But once you understand what is to be done, and then develop it with the client, run past it through them, seek confirmations, always write bubble comments. So sometimes, when we get into the roles of drafting for the first time, we feel, I should know this, or is it okay to ask the client? It's always okay to ask the client on scope, on commercial terms, on operational terms. Legalities, yes, you can decide, or you can suggest to them also that, use, if you want to use arbitration. Now Mediation Act is also there. So should I put a mediation clause? Explain to the client, give them those 2-3 minutes extra. Tell them what is mediation, tell them what is arbitration, and tell them what is, legal litigation, they will generally know. So should we include mediation? Should we include arbitration? Can we include, if it's an international party, then should we go for, should we go for SICA? Should we go for MCIA? Should we go for LCIA? So all these things, discussion is very important when it comes to contract, Jolly. So just sitting with a laptop in front of you, not talking to anybody, you're not going to get the best draft out. It's very critical to understand from them, ask them questions, and have a checklist, like have a proper question answer bank with you, that acha term is this, there is no lock-in, there is no exclusivity. So exclusivity is another important factor. If you're doing a distributorship contract, ask them, is there exclusivity, is there no exclusivity, have you defined any territory, have you not defined any territory? So once you have clarity, then then the draft develops. So I don't believe in, straight away, "Acha, theek hai, I need a distributorship agreement," dish out a template and give it to them. That is not going to be very useful for either you or for the client also, because the client will also, if you don't ask questions, I don't think anybody will bother answering anything.
Absolutely, ma'am. The moment you mentioned the template, a very important question came to my
Yeah.
mind right now. That we as legal professionals encounter clients who are very well read and come up with the
Uh-huh.
templates already. That see, I have drafted all these, and you just need to go through it. And so, how
And
do
tell
you
me, yes.
approach to deal with those kinds of clients and handle them and try to make them understand that this is not how it works, not internet has it all, and we are here to help you? How do you approach for it, ma'am? It is
So,
very important for legal professionals, especially for those who are into contract drafting and everything,
yeah.
because we very much encounter those kinds of clients.
Definitely. See, what happens is, I mean, a lot of times, as you rightly said, a lot of clients feel that, "Acha, okay, let me just get it from some source on the internet." And I think, I mean, to make us feel better, I think we are not the only ones. Even doctors are facing this. So my mother is
Yes.
also a doctor, and she does not practice. She was into teaching. She was, but I hear a lot. I used to meet a lot of her friends. So her friends used to share this incidents with me a lot when internet was new. And so my mother, obviously, so it's a senior generation. So the patient will read everything. Acha, theek hai, no, this has these 5 side effects. Why don't you give me this? And that has another side effect. So, can we just combine this two? Is there any? So, the more knowledge which is getting disseminated everywhere, the more we would say questions are bound to come. So when questions, or rather suggestions, or a particular way of functioning, because initially knowledge was not very readily available to others, or to it was available in a particular class of people who have, say, passed out of a law college, who have access to that law college or to the library, or who have access to a senior's office with all the drafts. Now with things on internet, these questions are bound to come, but I think good humor is a good way to handle it. We can always, and you can't discard it also, because
No.
I personally don't feel that everything on internet is rubbish. Yes, some portion of it might be useful, some portion of it might not be useful. You have to customize it, and when you logically, I think, explain it to the other party and give them time that this is how it is, and it is right on these aspects, it is not right on these aspects. So that conversation skills need to be built in that case, because sometimes when we look at any profession, acceptance is very important first before you explain your own point of view to them. So once you explain it, once you see, and if you outright reject, and if you outright say that, "Achha, I'm not going to do this," so I don't think the client will also have anything to do with you. Ultimately, the client also has to stay, no?
Yeah, client is the god. Yes. So,
Yeah, and the client doesn't know that he's the god. So client may whatever, I mean, we have to have gratitude also to every opportunity which comes to us. And sometimes they come with things which they have seen, which they have read on internet. And to be fair to you, I told you the best opportunity is always when the client is involved. See, when the
yeah.
client is not involved, no, it is difficult, because the client will not understand, and they might, or rather, when the client does get involved, the stage is already passed. Like, if the client does not read the contract at the time of signing, but reads it when the other side sends him a legal notice, and then says, "Oh, why did you write this? I never told you to." So you will say, "There was a comment
Yeah.
for you for confirmation. You never said anything." So, that's when the problems arise. So it's always good when the client is involved, I feel. And if they're making an effort to get something from the internet, so be it.
Definitely, ma'am. Uh, so moving to the last question for our conversation, that be law being dynamic in nature, and the
Hmm.
technology and commercial contracts are so much in trend and developing day by day. People are being aware that how contracts and agreements are very crucial in
Yeah.
their day to day life, and not only the big companies and the big organizations needs to get that signed. So since these kinds of awareness is being spread out, so more and more opportunities is coming up for the legal professionals. So what do you suggest should the legal professionals currently focus on for getting ready a kind of for the technology and commercial contract domain, if I may say. Like,
You can never be fully ready. See, because what comes actually is when you cross the bridge, you know what is there on the bridge. But getting yourself equipped is very, very, very critical. And when anybody is entering into this realm, I would say that, it's a mindset that we have, that we say that dispute resolution or litigation is different and contract is completely different. See, it's all interlinked. We are part of one field. And unless and until somebody has gone to the courts and or read the judgments for, read through the details that the questions that the judges may pose or the judges may ask, it's not possible to do contract drafting alone in isolation. Because, then sometimes then say, Acha, these are boilerplate clauses, we can just put them the way they are. So there is nothing which is boilerplate. You have to look through every word of the contract. That is something which we must all know. And developing skills, it's very important for us also to embrace technology. Because unless and until we embrace technology, we are not going to move with the pace at which the world is moving. So I personally always feel that it's good to stay updated through various things which are there. I also use apps, I also use websites, I also use search engines to quickly get information so that, I am also updated at the same time. And, I am not required to be told by somebody that, okay, you don't know it has come here or it has come there. Staying updated with legal news, staying updated with the latest judgments is so easy these days. It was never so easy when I started working, or when I started my profession. I remember we used to write down our notes in the libraries. We had to look through the judgment. Otherwise you have to go and get a Xerox of it. You will not find a soft copy of the judgment so easily on a smartphone, which you can just read even when you're on the even when you're traveling or you're on the bus or something like that. So I think the way things are progressing, updation and regularly updating your own self with what technologies are available for the professionals, it's always helpful. There's no reason to say no to it.
definitely, ma'am.
And
That
growth
is
mindset is, I think, something that, I mean, sorry, I cut you across, but growth
no, no,
mindset
no.
is
Please
something.
continue, ma'am. Like, finish your answer. Yes, ma'am.
I was telling you that growth mindset is very important. See, traditional skills like, what is good for a lawyer, say critical thinking is very good for us as lawyers. So developing our own critical thinking and independent point of view is something which matters in in every field where we work, whether it is litigation or whether it is contractual drafting. If you don't have your independent point of view, if you have not analyzed it, or you have not thought through the thing yourself, you're not going to be adding too much value. See, it's not like just writing English for them, for the client. We should have our own independent point of view, and then of course apply the latest legal judgments which you see, the latest legal developments which happen, the new laws which come forth. So that's like that everybody has to do. And to think of us as a composite profession is very important, I would say. I mean, whether it is traditional contract, technology contract, or a dispute resolution lawyer, or a litigation lawyer also. So it's good to be together.
Yes, ma'am, definitely. So, ma'am, that is it for our today's conversation. It was a very interesting, like, how much of time we have like spent talking like freely.
Yeah.
I have not even like recognized. Um, so thank you so much, ma'am, for giving out your
Pleasure.
valuable time. I am sure our viewers are very much enlightened and intrigued for learning about commercial contracts and technology
Definitely.
contracts a lot more, and they are much more curious now. So thank you so much. It was great having you. Thank you so much,
Thank
ma'am.
you. Thank you so much, Jolly. It was a pleasure to be here. I'll be happy to
Same.
touch. I mean, if I think you put this up somewhere. So if anybody has any queries, they can always reach out to me personally. I'll be happy to help anybody.